today is our trainings on Landmarks 101. I hope many of you had the opportunity to enjoy and hear the training on Monday, was it? Tuesday, on Land Use and Zoning 101. And have also had an opportunity to register for advanced land use next Monday. And you probably also saw that we added an additional trainings on conflicts of interest. So please look at your email inboxes for an announcement on conflicts of interest training, which will be led by the Conflicts of Interest Board. So we're very happy about that. In addition, we're working on other trainings with the Department of City Planning, as well as the Metropolitan Association of Parliamentarians, to bring you trainings on Robert's Rules of Order, as well as the intricacies, ins and outs of drafting a statement of district needs. And we'll be partnering with the Department of City Planning for that. So today we have Landmarks, and to present on Landmarks, we have Lisette Chaparro. Lisette currently serves as the Director of Land Use for the Manhattan Borough President's Office. In that role, she advises the Borough President on a wide range of planning issues and helps to support Manhattan's 12 community districts on matters related to land use, historic preservation, which will be the topic of today's training, and construction. Prior to joining the Manhattan Borough President's Office, Lisette worked for not-for-profit affordable housing developers in Hell's Kitchen and in East Harlem. In these roles, she managed construction projects, resident engagement initiatives, and conducted outreach to stakeholders and advocacy groups on a large-scale developments and zoning proposals. These projects included the redevelopment plan for the Port Authority bus terminal and the 2018 zoning text amendment for the Special Garment Center District. Lisette graduated from Brown University with a BA in Urban Studies and received an MA in City and Regional Planning from Rutgers University. So without further ado, I turn it over to Lisette Chaparro, who's the Director of Land Use. Thank you so much for doing today's training.
Thank you, Aldrin, and thank you everyone who has called into tonight's webinar. So Aldrin mentioned tonight we're going to be talking about landmarks in New York City with a particular focus on community boards. Some of the topics that we're going to be going over tonight include the provenance and history of landmarks, as well as the types of landmarks that we have in the city of New York, and landmark and zoning and the intersection of both of those topics, as well as the processes that we have for our landmarks in New York City. Just so everyone knows, you will have questions throughout this presentation. You can enter them into the Q&A box. And at the end of both section 2 and section 4, I will stop for questions. And at any point, you can sort of ask either general questions or questions that are referring back to earlier points of the presentation. Okay, so let's talk about the very beginning of the preservation movement in the United States. It really begins in the late 1800s with the City Beautiful movement. This is really a movement that is a response to the Industrial Revolution, as well as a proliferation of tenements in many cities throughout the country. It's really about the notion that you can have order from chaos, right? And that if you create grand urban spaces, that those spaces can really foster civic engagement in our cities. Following that period, the more significant point in the timeline here is urban renewal, which took place in the 40s and 50s, and to some extent the 60s as well. We're talking about an era that's right at the cusp, at the end of World War II. So you're seeing a lot of slum clearance And there's also a rise in suburbanization as well, right? And as people who are moving into the suburbs, cities are sort of looking at sort of starting on a clean slate in terms of development. And so this period of time sees a lot of demolition of historic structures, including the aquarium at Castle Clinton, the Ritz-Carlton, as well as the St. Nicholas Church. There were some advocacy groups that were opposed to these plans, including the Municipal Art Society, which is still around today. Those organizations really focused on preservation and pushed for a citywide ordinance to protect historic structures. We also have Berman v. Parker. This is a case that goes before the Supreme Court in 1954, and it's essentially about the government's ability to clear what they deem to be blighted areas. And as a result of this case, the Supreme Court rules that it's within the power of the legislature to determine that a community be beautiful and healthy. We see after the Berman v. Parker case, 2 years later, the state of New York enacts the BARD Act. This is a piece of legislation that enables local municipalities to regulate land based on historic and architectural merit. At the same time, though, there continue to be both demolitions of significant historic structures, as well as threats to some of the most beloved buildings in New York City. Most prominently, we have Carnegie Hall. The Carnegie Hall itself was actually under threat of demolition. And really the one thing that was able to stop that from happening was the fact that the city of New York purchased the building. Over at Grand Central, there was a proposal to build a bowling alley right above the main concourse, which would have completely obscured that famous ceiling that we all have come to admire at one point or another. And then finally, Penn Station. So Penn Station is really the example that folks point to as the one building that sort of catapults the landmarks movement, not just in New York City, but also across the nation. So for many years, Penn Station had not been well maintained. And we're talking about a time in the 60s where the rise in suburbanization means that we're also seeing a decline in the use of railroads. And so as a result, the station itself is demolished and eventually replaced with what we all know as the current Penn Station. The demolition took place in 1963. And it's somewhat notable that just before, 1 year before, the Landmark Preservation Commission was established by the Board of Estimate. However, the LPC, as we call it, everything that they decided was advisory in nature. So they had at this point no ability to really regulate buildings. And so it is actually after the LPC is established that we see the demolition of Penn Station. However, at its inception, LPC does designate some honorary landmarks and sort of starts to prepare a legislative program that becomes the basis for the LPC that we all know today. In 1965, New York City passes the Landmarks Law. it essentially creates the LPC, again, like I said, the one that we know today that has regulatory power. We'll talk much more in detail about what that means in terms of what can and can't happen in historic buildings and historic districts. The pieces of language that govern LPC are both in the administrative code as well as the city's charter. Nationally, we have the Historic Preservation Act in 1966. And this is what creates the National Register and the State Historic Preservation Office, or SHPO. We also have a Section 106, which is a process through which federal projects have to go. We'll talk about that much more in depth later on in the presentation. Just want to note, while LPC at the city level has regulatory power, both SHPO and the National Register of Historic Places are non-regulatory agencies. So the Landmarks Law is really about the protection and enhancement of historic resources. When we're talking about historic resources, we're looking at places that have some architectural significance or have had users in the past that have historic significance or a cultural significance. And there are different thresholds both at the state, national, and city level for how old those structures have to be considered eligible to be designated. But in general, the law is really about protecting those structures. It also aims to stabilize property values in neighborhoods and in historic districts. It's about fostering pride in these areas of cultural and historical heritage, as well as attracting tourists, visitors, again, strengthening economies of our city, I should say, and to generally promote our historic and cultural heritage. LPC itself is comprised of 11 commissioners. They're all appointed by the mayor. All the commissioners, except for the chair, serve without pay, and they have 3-year terms. 3 of the commissioners have to be architects, 1 has to be a historian, and 1 has to be either a planner or a landscape architect, and then 1 has to be a realtor. LPC can designate as well as regulate both landmarks and historic districts. And they also are tasked with deeming whether or not an alteration to a landmark is appropriate. Appropriate is not actually a defined term. It is a subjective decision that is made by the commission. In 1973, the Landmarks Law was amended to allow LPC to designate interior as well as scenic landmarks. And we'll talk a little bit more about what qualifies as each one of those. And then finally, and some folks who have looked at or participated in rezonings may be familiar with the fact that LPC is also responsible for listing and identifying historic resources as part of an environmental impact assessment of a project. So oftentimes when there is a proposed rezoning, LPC will list out buildings that are in that area that have historical significance. Some of the first designations that LPC did upon its ability to actually regulate included New York City Hall, Brooklyn Borough Hall, St. Patrick's Cathedral, the Brooklyn Museum, the New York Public Library, the Met, Carnegie Hall, the Flatiron Building, and Grand Central Terminal. The first historic district was actually in Brooklyn Heights. So we talked about the Berman v. Parker decision, as well as the BART Act. There are also a couple of other Supreme Court cases that really cement the fact that commissions like LPC throughout this country have a right to regulate historic properties. One is a decision that came out in 1978. Penn Central was basically seeking to redevelop Grand Central Terminal and build an office tower above it. The LPC determined that that was not an appropriate alteration to this landmark, and Penn Central then sued under the Fifth Amendment, claiming that the decision was a violation of their due process rights. As a result, the Supreme Court rules that historic preservation is a public purpose. And in addition, that Penn Central does have a right to just compensation under the existing regulatory framework, specifically because Penn Central is able to sell their development rights. And we'll talk a little bit more about how that applies to and works for landmarks in New York City. The second Supreme Court decision that we want to highlight is a 1990 decision, St. Bartholomew's Church in East Midtown. Again, this is a landmark building that wanted to build a tower and was not able to do so, did not obtain approval from LPC to do so, and claimed that the decision was an undue burden and a violation of their First Amendment rights, their ability to practice religion freely. Again, here the Supreme Court really reinforces their prior decision from 1978 in the Penn Central case in saying that historic preservation is something that is a public purpose, and that there are other mechanisms under which St. Bartholomew's can essentially again, sell development rights and proceed with whatever it is that they need as an institution. We'll talk a bit about landmarks. It's just a reminder at the end of this section. I will pause and take questions from the Q&A box. So a landmark is a building, property or object that has been designated by the LPC because it has a special character or special historical or aesthetic interest or value as part of the development, heritage, or cultural characteristics of the city, state, or nation. So when we're looking at landmarks, we're looking at buildings, at least individual landmarks, that have a distinct architectural style. We're also, again, like I mentioned earlier, looking at the users of the building, right? So if the building was frequently used or used for a significant period of time by a person or a group of people that have historic or cultural significance, that's also one of the things that the LPC will look at. And then in some cases, we're also looking at buildings that implemented or pioneered certain engineering techniques. That's another of the frequent standards or aspects of buildings that LPC will consider. Landmarks, as I mentioned, are designated by the Landmark Preservation Commission. They do not require the owner to provide permission for designation. The structures have to be 30 years or older. And once they are designated, if they have to have renovations made to their facades, they are eligible to receive grants from LPC. The types of landmarks include individual landmarks. If a building has an individual landmark designation, LPC is tasked with regulating what happens to the exterior, the facade, as well as the grounds of the property. We also have interior landmarks. These are sort of interiors of buildings that have to have been customarily accessible to the public. So I have actually, I'm aware that Gail, who many of you will know, is a huge proponent of historic preservation. You know, she very much wishes that the interior of her house could be designated. However, as a place of residence, it is not customarily open or accessible to the public, so therefore not eligible. Interior landmarks cannot be places that are used for religious worship. And we also have scenic landmarks. These are pretty much parks that are owned by the city of New York. And then lastly, at a larger scale, we have historic districts, and we'll give an example of one of those and talk about how those operate as well. Actually, the very next slide. SoHo, NoHo, the first designation that we have is in 1973. There's an extension that takes place in 2010. And then NoHo has its first designation in 1999, followed by 2 extensions in 2003 and 2008. And then finally in 2016, we have the Sullivan-Thompson Historic District, which is just north of Broome Street. One thing that, that is key for historic districts is that they have a cluster of buildings that were built around the same time and that have similar architectural styles. So, right, when you're thinking of SoHo, you're thinking very often of those grand cast iron buildings, and the fact that there aren't just a few of them, but a whole row that sort of make a district, and that kind of street continuity is one of the key elements of historic districts. A historic district can have a contributing and a non-contributing building. You know, if you look at this map, which highlights the districts themselves, you know, not every building is going to be super significant. You may even have, you know, a one-story nondescript building because, you know, there was a fire decades ago and someone rebuilt something very, very quickly and doesn't have much historical significance. But we'll go more into detail. I should note that there are buildings within historic districts that are not individual landmarks, although historic districts also have individual landmarks. And so there are different approval processes for buildings that are within a historic district and are not designated as individual landmarks. An example of an individual landmark will be the Astor Library, which is sort of in the cusp of SoHo and NoHo. This is today known more frequently as the Public Theater, but was at one point also the Hebrew Immigrant Aid Society building. This is a little snippet of the LPC's designation report from 1965, which was the date that the building was designated as an individual landmark. Nowadays, the LPC will have a much more robust report sort of outlining the history and the significance of the buildings that they designate as individual landmarks. An example of an interior landmark, Bleecker Street. This was designated in 1979 in recognition of the fact that the IRT line was a key part of the development of the New York City subway system, right? And it does have beautiful tile, a decorative tile that is distinct from what you see in many other train stations. And also notable that this, as an interior designation, is a place that was customarily open and accessible to the public. So to talk a little bit about the state and national system, as I mentioned, in 1966, we have the Historic Preservation Act. We have also at each state a Historic Preservation Office, or what we'll refer to as our SHPO, New York SHPO. They have a list of properties that are on the state/national register of historic places. The threshold to be on that list is a bit more, is a bit higher than for the city of New York. Properties have to be 50 years or older. And then also, just like at the city level, have to have a significant historical, cultural, architectural, archaeological, or technological component. This listing does require owner permission, however. Properties that are on this list qualify for a variety of tax credits and are subject to Section 106. The tax credits that these properties are eligible for include a 20% tax credit for rehab work that is done on properties that are listed on the National Register, as well as a 10% tax credit for properties that are not listed but were built before 1936. At the state level, there are also tax credits, a 20% tax credit for properties that are listed in the state register and that are located in qualifying census tracts, and a 20% tax credit for any historical residential structures up to $50,000. So Section 106 is a part of the law that really aims to both disclose the effects of a federal project and also require consultation on what the effects of that project will be. It's basically any project that is receiving federal funds has to essentially have a review process in conjunction with the local state historic preservation office, as well as other stakeholders. There is a whole scoping process that has to take place to determine what effects will be taken by the historic properties that are in the vicinity of the proposed project. There are also studies that have to be made to find any properties that are eligible or that are already listed on the National Register. The applicant also has to consult about what those effects may be and which ones are going to be adverse effects on the local community as well as historic resources. And finally, there's a memorandum of agreement that has to be executed that outlines how those adverse effects will be resolved. So we can pause here. I think there are a few questions that we've gotten in our Q&A section. So I'll just open those up. And for some reason, I'm not able to open up the Q&A section.
If you like, I can read you the questions then.
That would be great.
Okay. Sorry about that.
That's okay.
So Elizabeth Rose asks, the intent of landmarks includes stabilizing, improving property values. I am troubled by the result that many landmark districts have become very expensive, high-income districts. Is there any concern about this more broadly?
Yeah, I think, so there is, when we talk a little bit, I'll give some figures for you know, where our landmarks and the different kinds of landmarks that we discussed, where they're located. I don't intend to speak on behalf of the LPC, but I think in the last several years, there has been a recognition, and I would say that it's perhaps a little bit of a chicken and egg dynamic, where I think that more frequently the observation is that the places that end up getting historic designation are places that are wealthier and oftentimes wider neighborhoods, right? And so I think that in the last couple of years, there's been a focus in trying to address other neighborhoods here in the city of New York. Again, we'll talk a little bit more about that further on in the presentation.
Okay, we have another question from Brian Pape. After you covered the legal basis for preservation laws and policies and provenance and history, will you then cover the limits of applying community wishes on a property? Thank you, Brian.
Yes, we will discuss that as part of the process section.
Next, we have Chanel Spence. Does the concepts of taking apply throughout, such as denial of a penthouse on a row house?
I think I'm a little unclear on what the question is in terms of it applying throughout. So can you repeat the question?
Yeah, does the concepts of taking apply throughout, maybe throughout a district, such as denial of a penthouse on a row house?
Yeah, so the concept of taking is basically that you can have a physical taking of a property. In other words, the city, you know, literally taking it and not letting the owner use it. But there's also a regulatory taking concept, which is basically that the restrictions that are placed on a property are so onerous that the owner can't achieve a reasonable return on their property. That is the concept of a taking is something that owners sometimes sue based upon that concept. And so it's not necessarily a policy that is applied, but rather something that is claimed by an owner, oftentimes as part of a lawsuit. And so I think with the townhouse addition example, you might be looking at, for example, an owner who doesn't get LPC approval to build an addition, and as a result of saying I can't achieve a reasonable return on my property, you know, I think many times the response to that will be that, you know, LPC doesn't say that you can't build an addition, but they are, and the Supreme Court has supported the notion that they can regulate how things get built and what they look like, because it is in the interest of the public good. So if that wasn't the question exactly, or if that didn't answer the question, feel free to
Yeah,
to
feel
ask.
free to elaborate again in the question and answer section
Yeah.
if that wasn't clear. Next, we have Elizabeth Rose again. Why can't religious worship buildings be landmarked interiors?
I'm not entirely sure. My guess would be either something having to do with the separation of church and state, but also just from anecdotal experience, I think that a lot of religious institutions will want to have more flexibility in that. But I can't say that I know for sure. If there is an answer, I will find out and we can send it to folks when we send both the presentation and any other information sometime later this week.
Okay. Another question is, what are the actual regulations for a facade not visible from the street opposite a faced in public view?
If it's not visible from a public street, and we'll talk about process, but just to answer the question now, there are approvals that go through LPC that are done at the staff level as well as by the commission. And so customarily, alterations that are not visible from the street. So for example, if you're doing something to the rear facade, those are items that can be approved by LPC staff. So that means that they don't necessarily have to have a public hearing and a vote by the commissioners.
Okay. The next question is, historic districts designations have to be renewed or extended? Is there a standard length of time before needing an extension?
So the extensions actually refer to physical extensions. The designations themselves exist in perpetuity. What often, or what sometimes has happened is that there is a neighborhood that becomes designated, and then advocates or neighbors or the community board even will organize to say, well, actually, a larger part of that neighborhood should be included. So many historic districts throughout the city have had extensions. And again, this sort of gets back to there has been criticism of where those extensions are happening and in what neighborhoods and what the demographics of those neighborhoods are. But that's, I'm sorry I wasn't clear about the extensions are not for a period of time. They're physical extensions to surrounding blocks of a historic district.
Thank you for that clarity. The next question is, with public demand growing to take down landmarks and monuments with racist connections, are the functions of the LPC changing to address this? Has LPC previously addressed a case like this?
So again, I don't want to speak on behalf of the LPC. I will note that statues and other structures that are similar to statues fall under the purview of the Public Design Commission. And so to some degree, I'm sure there's overlap if you have a statue that's part of a scenic landmark or that is in the interior of a building that has been designated. But by and large, statues that are outdoors, that are part of the public realm, are under the purview of the Public Design Commission. And I'm not aware of any statements that either LPC or the PDC have put out in regard to the very important conversation that is happening locally and nationally about statues.
We have another question. Please elaborate on the eligibility requirements for the 10% federal tax credit for non-NR, and I guess NR would be what, National Registry, properties built before 1936?
Yeah, so I mean those are pretty much the thresholds. I think part of the process with the National Register, when you are getting the tax credits, and this applies to all of those tax credits, the owner has to demonstrate, and in particular for sites that are listed, but also ones that are considered eligible. They have to demonstrate, there's like a whole business of historic consultants who are very well versed and will do the research. So, at the point that the property is actually seeking the tax credit, they've done the research, they've demonstrated the historical or cultural, archaeological, technological significance of the structure, and for the proposed work in particular, there is a plan, and there are architects and engineers who come on board to demonstrate not just the work that the owner wants to do to the property, but also to demonstrate how it preserves the building. And so depending on a number of things, including what the scope of work is, how much of the interior is preserved, and what materials are being used, and how if you have historic molding in the interiors, are you preserving that? So oftentimes there are requirements to preserve elements of the building, but other than that, the basic threshold that a property would have to meet if it's not listed in the register is that it is built before 1936.
Thank you. Dimitris Garnarders and others have asked, will you share the deck and the recordings? And the answer is yes. We will be emailing or sharing the link for everyone in terms of this Zoom training recording along with the deck. And Dimitri Garnarders also asks, are there any tax credits or financial assistance from the city for owners in landmark districts?
So the only one that we mentioned was the grant for individual landmarks that are seeking to do facade work. And we can provide more detailed information to folks on that when we send the slide deck.
Okay. Next question. The SHPO consults with the community boards in an area where there is a 106 project.
SHPO themselves does not, though part of the requirements of 106 is that that the applicant consult with local stakeholders. So pretty much in every case, you're looking, depending on the scope of the project, right? But if it is a building that has a sort of a large citywide significance, then you would look at a consultation that has a scope that's larger than a community board, I would imagine. But in many cases, yes, that will mean consultation with the community board and or some other local groups.
And this next question, I think it's related to a previous answer of yours, which is, does the LPC have any involvement in the Museum of Natural History's Theodore Roosevelt statue and any such statues, like Christopher Columbus statue in Columbus Circle?
So again, my understanding is that both of those statues being situated outdoors would fall under the purview of the Public Design Commission. And we'll verify that, but I'm almost certain that that's the case.
Okay.
So it's the Theodore Roosevelt and the Columbus statue, right?
Yes, correct. Is there if a building in a historic district is demolished due to a fire, does the replacement structure need to be contextual?
Yes. So new construction in historic district is subject to some review from the LPC. I would also note that if and when a historic landmark has a fire and has to be demolished as a result, that the LPC also has to take an administrative action to essentially remove the individual designation of that building.
Is there a time period for the LPC to act in designating a property a landmark?
Yes, and we will talk about that when we get to the process part.
Okay. Next question. Approximately how many of the LPC designations have been made over the objection of the owner? The Strand comes to mind as a contemporary example.
Yes, there was a Strand, and I think recently there was a designation of several buildings in Tin Pan Alley as well. In many cases, so I should start with the big answer, which is that I don't have those numbers. But what I will say is that when the LPC, we'll talk again about process, when they start looking at a designation of a historic district or an individual landmark, they do work with property owners and oftentimes are able to, while they are undertaking their research at the staff level, they're able to get an agreement from the owner or owners that they will not do any significant work to their properties while the LPC is, preparing for a public hearing and then eventually headed down a path toward a commission vote to designate or not designate a property or a district.
This next question is, can you speak about the impact of eminent domain, especially from universities and hospital institutions? Also, historic context of Brooklyn Heights Historic District.
So I think if you can clarify that question a bit more, I think, yeah, I'm just not clear on what about eminent domain and historic.
Ronald, if you can clarify the question a bit more, we'll come back to it.
Yeah, and the answer on the Brooklyn Heights Historic District, I must say I'm also not able to provide further information on as a planner for the Manhattan Borough President, but what I will say is that the LPC website does have the designation reports for both individual landmarks and historic districts, as well as interior designations and scenic landmarks. So you're certainly able to go on the website and find a very extensive report from the commission on any of the things that they've designated.
Okay. Next question. Do exterior buzzard and intercom systems require hearings or LPC approval? Interesting question, right?
Yeah. I am not. If we're just talking about a panel, that I'm almost certain would be something that is a staff level approval. We can confirm because it does fall into, it's such a small thing, and yet it is on the facade, which is under the purview of LPC. It definitely requires LPC approval, but I'm just not sure if it's something that can be determined at the staff level or like many facade items, have to go through a public review process. I should note that there was a rule change in 2018 that essentially left the threshold for or created a threshold for any new any changes to facades that are less than I believe 18 inches. That those can be approved at the staff level by and large. So I guess if we're talking about an intercom and it's within that threshold, then we are looking at a staff level approval. But I will clarify and send that information to everyone.
Can you explain a little bit the difference between staff level approval and commissioner level approval?
Yeah, we can when we get to the process section.
Okay, excellent. And then a related question about the buzzards, I think, is when replacing wooden windows in a historic district, could alternative materials be used provided they maintain the original appearance? What approvals are generally needed?
Well, for approvals, we can talk a bit. I think a lot of these questions are about process, so hopefully we'll be able to clarify. In terms of materials, yes, these are ongoing conversations that an applicant will have with the LPC. There are different materials that are usually permissible to replace whatever historic material was used on something like a window. I can't speak to as we said earlier in the presentation, these are subjective decisions that are made by the commission, and so there is very much a discussion between the commission and the owners in terms of what materials can replace what was historically there.
Okay, I think this is a good time to then segue into the next section.
Sure. Okay, so we'll talk about landmarks and zoning. There is quite a bit of intersection between these two pieces here in the city of New York. In every historic district, you also have zoning. So you're talking about sort of two layers of regulation that exists in these districts. And in addition to that, historic landmarks also have the ability to obtain special permits as well as privileges around the transfer of development rights. So the special permits that a historic property can obtain includes a permit under section 74-711. This is most often a permit that's sought in Community Board 2 of Manhattan, in particular in the SoHo neighborhood. So this permit is essentially to allow for permissions regarding variation in use or bulk and height of a building. Section 74-712 is for properties that are within a historic district that are underbuilt or have vacant land, and also provide some flexibility with regard to both height and setback. And 74-79 is the section of the zoning resolution that allows a landmark to transfer their development rights to a broader radius. So typically in most other parts of the city and in many other scenarios, when we are looking at a transfer of development rights, you're limited really to an adjacent property. There are some exceptions to that, but by and large, you are limited to transferring your development rights to an adjacent property. Section 74-79 essentially allows a landmark to send their development rights or to sell them to a property that is either across the street or that is that shares an intersection with that landmark. So we'll talk about that a little bit more in depth, but I just want everyone to know transfer of development rights can get very complicated. This is a subject that is covered or was covered on our Landmarks 101 training on Tuesday. I believe the video for that is up on our YouTube already. And we will cover it also more in depth on Monday evening when we have our advanced land use training. But 7479, again, is a special permit that a landmark can get to transfer the development rights. If you look at the bottom left, this is essentially a diagram showing you what a transfer of development rights is, right? So you have a landmark. They, according to the zoning, could build a building that is much taller. And that's the outline that you see above that landmark. And they then sell the rights to build that extra square footage to another site. And that other site is then able to build taller than they would otherwise be able to do. We also want to talk about the special Midtown Theater Subdistrict. This is a subdistrict that allows theaters to sell their development rights within a broader range, essentially within the boundaries of that subdistrict. The goal here being that theaters then be able to obtain enough money to undertake capital improvements and therefore be able to operate in perpetuity. The Special East Midtown Subdistrict also has a similar provision, in particular for landmarks, and this was passed in 2018, so much more recent addition. Again, you have the concept that within a subdistrict, landmark can transfer their development rights to other sites. So let's talk a bit about process, much awaited. Process for getting either a potential landmark or a district really starts at the neighborhood level. In this example, we're showing a report that was prepared by Manhattan Community Board 10 that really identified some of the historic resources in their community that they thought should be further researched and potentially considered for designation. The second step from there is to submit an RFE or a request for evaluation. This is a pretty simple form that can be filled out by an individual, an advocacy group, or even a community board. The RFE really is an initial case being made for the designation of that area or that property. You can include documentation and photographs as well as historic research as part of the RFE, and the more of that you include, the more likely you are to make it to the third step, which is a step that is undertaken by the staff of the LPC. LPC will take that request and then do some research and come to a determination as to whether or not the property should be further researched for potentially being landmarked, or whether it's not a significant enough property in terms of history or culture. The LPC also does sometimes send letters that say that a property or a district does have some historical significance and it does merit further research, but those steps will be taken in accordance with their priorities. And so this sort of gets back to the conversation that we had about, where should we be focusing and how should the city approach landmarking in a way that is equitable and fair to communities that are not as wealthy and are not as white as the ones that have been historically the ones to be designated. The next step, if the LPC determines that a property should be studied further, is then to calendar the property or area for a hearing. This is the city record of the city of New York. If we were in a room, I'd be very curious and ask folks to raise their hand to see how many of you all have had a copy of the city record and actually read through it. This essentially is a notice that there will be a public hearing on the proposal to landmark this property or this area. Then the public hearing takes place. The LPC staff will present their research, and members of the public can speak either for or against the proposal to designate the building or the area. Finally, but at a certain point, there is a vote from the LPC commissioners. There was legislation passed in 2016 that requires that the LPC vote no later than 2 years after the item was calendared. Prior to that, there was no timeline. And so the LPC actually at one point, I believe in 2016 or 2015, had a backlog of buildings that had been calendared and or heard, but had not been voted on. The 2016 legislation requires that that LPC move to either designate or not designate, or the third option is to say that they just simply don't have enough information to vote one way or another. And so they kind of leave the door open in terms of whether or not there is more supporting historical evidence that can be found. And then perhaps one day the commission can sort of reconsider the item. After the LPC vote, the City Planning Commission then holds an advisory vote on the matter. And then finally, we have City Council vote. Their vote has to take place 120 days after the LPC vote. So whatever amount of time CPC takes, then the City Council sort of has to take the torch and bring it there to the finish line. So I want to talk a little bit about landmarks on a borough by borough basis. So Manhattan is actually pretty covered compared to some of the other boroughs. Although again, if Gail had it her way, we would be seeing 100% in all three of these categories, I think. In terms of individual landmarks, Manhattan has 64% of those. The second highest being Brooklyn with 14%. Historic districts, we have 54% of those in Manhattan. Brooklyn is second again with 27%. And then buildings and sites that are under LPC purview. So this includes not just individual landmarks, but also buildings that don't have individual designation, as well as buildings that have interior designations, as well as scenic landmarks. When we tally all of those up, Manhattan actually is second to Brooklyn, but a close second. Brooklyn has 44% of all the buildings and sites that are regulated by LPC, and Manhattan has 38%. So still very, very robust numbers there for Manhattan. And as you can see, this map sort of, it outlines both the historic districts as well as individual and interior landmarks and scenic landmarks. this had so much going on that we had to sort of cut the map in half, so you would be able to see the coverage that we have throughout the borough of Manhattan. So LPC's regulation of landmarks, it has to do with both, you know, the designation, but also proposed alterations that an owner is seeking to make on their property. So for ordinary maintenance and repairs, there is no review or approval required from LPC. A permit for minor work is granted by the staff when there is some work that has to happen, but it doesn't even rise to the level of needing a permit from the Department of Buildings. The commission also grants authorization to proceed when there is work that is part of a master plan. So for example, if you have a large building that is an individual landmark and you are going to be replacing the windows, but you're not doing it all at once, you can submit a master plan to the LPC that essentially lays out what kinds of materials you're going to be using, how many panes are going to be in the windows. All of that can be pre-approved by the LPC, and then you can have authorization to proceed once you are ready to actually undertake that work. LPC also grants a certificate of no effect for any significant work that won't actually influence the features of the building that are protected, most often the facade. But of course, in the case of interior designations, the interior as well. Certificates of appropriateness are issued for work that would affect the features of the building, but that are nonetheless considered appropriate. And again, when we use that word, we mean it in a subjective sense, and the commission is sort of tasked with deciding that on a case-by-case basis. This certificate has to be obtained by both existing buildings that are doing an alteration, as well as any new buildings that are built. So that was one question that was raised earlier on. So if you have an empty lot and in a historic district and you want to build a brand new building, you have to get this certificate of appropriateness. This is the first item on this list that requires a public hearing and a vote by the commission. And then lastly, the commission does grant authorization, or can grant authorization for the demolition, alteration, or reconstruction of a historic structure based on the owner's inability to get a reasonable return. So again, getting this authorization requires a public hearing and a vote by the commission. In terms of properties that are found to be in violation of LPC's rules, there are sort of 5-step process. So the commission can issue warning letters, can issue a notice of violation. It can work with the Department of Buildings to issue a stop work order. If the owner then takes action, the commission can also issue a certificate of correction. And finally, there is the Environmental Control Board, or the ECB. So the ECB is tasked with adjudicating the rules of the LPC, and they can actually impose fines and civil penalties against owners who are not able to cure the violations that have been filed against their properties. The community board's role for those items that require hearings by the LPC, Very often, the applicant will come, almost always in what I've seen, to the community board as well to present their proposal. And the community board then can draft recommendations on those proposals. So again, those are for certificates of appropriateness, as well as for those special permits, right? So, and this is actually a hearing that is required as part of the ULURP process. Again, we talk about ULURP in Land Use 101, but it's a separate public review process for land use actions. And so community boards will hear a matter that has to do with, you know, height and setback exemptions for properties in historic districts, as well as for landmarks that want to transfer development rights. Community boards can also partake in research and advocacy. And in particular, they can sort of put the foot forward and try to submit a request for evaluation of either a building or a district. Also, as part of the environmental review process, they can submit comments to either as part of the ULURP process to the Department of City Planning, or as part of the 106, Section 106 process to the federal agencies that are undertaking that review process. And then finally, community boards are really sort of the eyes on the street for those of us in city government who, you know, are tasked with serving you. And so to the extent that you believe that something needs further consideration, you know, our office and the LPC are certainly open to hearing from you and hearing not just about individual landmarks and historic districts and what should be designated, but also about how processes can work to better serve you know, communities and better protect the historic resources that we have in our communities. Lastly, I want to go point to some online resources that we have. I've got the link to the LPC's website, as well as the National Park Service, which is the agency that is at the federal level in charge of historic preservation, and the New York State SHPO office. The Neighborhood Preservation Center is an organization that is dedicated to facilitating and encouraging citizen participation in the improvement and protection of New York City's diverse neighborhoods. And obviously they have a historic preservation focus. And the Advisory Council on Historic Preservation, an organization that has a similar interest, but also has a nationwide scope. Some advocacy organizations, the Landmarks Conservancy, Historic Districts Council, the Municipal Art Society, which we mentioned earlier in the presentation, and the National Trust for Historic Preservation. The first three are New York-based institutions, and the last one obviously, again, has a federal scope. And lastly, I just want to leave you all with the list of our staff members in the Manhattan Borough President's Office, Land Use Division, and our respective community board assignments. I'm gonna see if I can open, I'm still unable to open the Q&A, so Aldrin, I will need your help here.
No problem. We have a question from Dimitris Garnaris again. Does replacing a window because it's cracked with the same window and not altering the frame material require review? Same for scraping and painting with same paint color.
So, so the window, yes, has to go through LPC. The scraping and painting, if it's of the exterior, also has to go through LPC. If it's of the interior and there's no interior designation, then no. So I should just take a moment to reiterate, when there is an individual landmark designation, and just that, the LPC's purview really is limited to the exterior of the building, not the interior.
Chanel Spence asks, can insufficient return apply to single-family house or properties, usually houses built as single family and converted to multiple dwellings, being converted to a single family?
Yes, that's the short answer. I think in Chelsea, I think more recently I've seen some plans for conversion of what used to be multifamily buildings into townhouses. Some of those have been a bit contested, more notably because they included rear yard additions, and are those kinds of applications that go before the LPC, are oftentimes scrutinized a lot by members of the community, but the answer is yes.
This next one is it's going to be my question, because we have a lot of new community board members listening in as well. Often when I attend some of the landmarks committees at community boards, there's a lot of discussion around landmarks and ADA compliance, the American Disabilities Act compliance. Can you tell us a little bit about landmarks and their compliance with the ADA, and at what points is it prohibitive, or is that not a standard, and what kind of conversations or issues community board members might be faced with around ADA and landmarks?
Yeah, so my understanding is it's also sort of a DOB question, I think, right? Because you are essentially grandfathered from ADA compliance in most cases. If you are talking about a really old building that doesn't comply, unless you undertake a significant alteration of the building. And so that definition and determination is housed within the DOB as an agency. So in most cases, you're not really looking at having that requirement unless and if you are undertaking a serious renovation of the property. And at that point, then yes, you do have LPC purview come into play. There is, again, the LPC process is a very iterative process. You're looking at sometimes months of back and forth in the lead up to the calendaring of a particular item. And so there are many discussions that are had about how to provide ADA accessibility while also preserving some of the historic elements of the building. But at the end of the day, the ADA requirements are what they are. And so a lot of times it is a negotiation between the preservation of the architectural elements of the building with the need to provide an accessible space.
Okay. We have another question. What is the Commission's regulation on the building of new roof decks and bulkheads on landmarked buildings?
So it is something that is allowed. Again, this has to go through the LPC and get a certificate of appropriateness, which has to happen through a vote of all 11 commissioners. There is no straight policy on it. As we've mentioned, it is a decision that is made subjectively by the commission, and there's ample opportunity for both community board input at that level, and at a hearing that takes place at the community board level, and also a hearing that takes place at the LPC for members of the community and other stakeholders to come in and express their support or belief that the addition is not appropriate given the physical context of that area.
Next question. When zoning regulations and LPC regulations are not in agreement, which set of regulations has precedence?
I don't know that I can think of any examples where both of those regulations are not in agreement. I think the way, I think that perhaps the more accurate way to think about it is to say that that zoning and landmarks sort of work in tandem so that landmarks are in fact able to have access to mechanisms in the zoning resolution that are aimed at ensuring that those landmarks can continue to exist in perpetuity. So those were the special permits we were talking about.
Okay. And Wayne Benjamin, we all know Wayne Benjamin. He's Community Board 12, great expert on land use and zoning as well. Wayne Benjamin asks, please clarify the answer concerning window repairs. Are you saying the LPC review is required to replace a cracked pane of a glass?
A cracked pane in particular, I'm not sure. We can get back to you on that, Wayne. For a whole window, yes, but a cracked pane, I mean, I think in some cases you're looking at, you know, when you look at a historic window, you're looking at glass that is of a totally different makeup. So I think there's a question of, if you have one broken pane and the rest of them look different, what do you do about that? But I can get back to you and everyone on the specific question of one single pane.
Okay. Next question. Similarly, if a townhouse is asking to restore a lost stoop and stair, does it need to comply with today's ADA stair requirements, or can it be replaced a stair that matches the original?
I'm not sure.
It's a good question.
Just a single step, right? That's what the question says?
If a townhouse is asking to restore a lost stoop and stair, I guess it's the whole stoop and stair, does it need to comply with today's ADA stair requirements, or can it be replaced with a stair that matches the original?
If it's the whole thing wholesale, I would say yes, ADA. Again, we can clarify. Yeah, if it's the entire stoop, then I believe it would be ADA, but we'll clarify.
Okay. With respect to roof, deck, and outdoor places, does the question of potential noise to neighboring properties affect a landmark's decision?
No, I mean, these are things that can be raised as part of a public hearing, but really the purview of the LPC is about the streetscape. If you're talking about a historic district, and if you're talking about an individual landmark, you're looking at the architectural elements of a building and whether or not that the addition is respectful of that design. But things like noise, you know, usually those are things that a community board can raise with an applicant, but they're not necessarily, they're not things that the LPC will evaluate in their vote necessarily.
Okay, I'm looking to see if there are any questions in the chat room that we haven't answered. There's one, can air rights be transferred to a landmark site that does not allow transfer? If yes, what is involved? Can air rights be transferred to a landmark site that does not allow transfer? If yes, what is involved?
Usually the air rights, the development rights, we should say, that's the official term. The development rights are transferred in the other direction, which is from the landmark to another property. The reason being that, if you're a landmark and you're trying to build higher, you usually could just use your existing development rights. So I'm not sure under which scenario you would have a landmark seeking to purchase them. I suppose you could have an example of one that perhaps sold theirs and then for whatever reason decided that they actually wanted to build an addition and they purchased development rights. That is permissible. I don't know of any scenarios where a landmark wouldn't be able to purchase development rights. I think the question then becomes whether or not the proposed addition is able to get LPC approval.
Got it. Wait, I think I see one more question. From Wayne Benjamin again. Just for reference, I worked on a renovation project in central Harlem of a brownstone properties located in a historic district. We were allowed to rebuild new stoops to match the original.
Yes. So I think that the question then becomes, what if the previous stoop does not have the right slope ratio to meet
ADA
requirements, which I just don't, not entirely sure. Again, my guess is yes, but we can get back to everyone on that.
Okay. Now, so we don't have any more questions and answers in the question and answer section. Let me see in the chat section. Also, the residents may not have to. Thanks so much for the great refresher. Also, if it's a residence, it may not have to comply with ADA. That's a comment from Jess Elliott in the chat section. So just in concluding, you know, I remember when it was the 50th anniversary of the landmarks law, about what, 3, 4 years ago. It was highly celebrated, and we did a lot of education around it, and we convened lots of panels around it, getting people's opinions of what they thought the future of landmarks in New York City will be looking like, or would look like. And that map that you showed, where you cut it around Central Park, and you showed the southern part of Manhattan, and you showed northern Manhattan, and visually you can see the difference of the disproportionate number of places and sites and buildings landmarked in lower Manhattan versus northern Manhattan. If you were to look into the future, 5, 10 years down the road, when we're celebrating the 60th or 65th anniversary of the landmarks law, what do you think the future of landmarks holds for the city of New York?
I think, you know,
be provocative, you know, those things that you've always wanted to share with an intimate group of like 70 people and not let it get out to anybody else, you know, feel free to do so now.
You know, I think I alluded to this a bit earlier when we looked at those borough by borough figures, right? They're particularly in Queens, Bronx, and Staten Island. There are very low numbers there in terms of recognition of historic places and areas in those neighborhoods, in those boroughs, I should say. So I think if we're looking at 10, 15 years into the future, and you know, I understand this to also be a goal of the city of New York and the LPC in general, is to have a more equitable view of you know, and consideration of what is deemed historically significant. And so I alluded to it both when we looked at those figures, but also when I shared that, you know, LPC can also send a letter And I think this is a very interesting wording, right? That they can say to someone who has submitted an RFE that, yeah, what you're directing our attention to does merit further study, and we will commence that study in accordance with our policy priorities. Those are not the exact words, but that is basically what they will say in some letters. And so I think, to me, that indicates that there is a conscious effort to, on behalf of the agency and the city, to really look at some areas that perhaps haven't had tremendous focus in recent years. You know, the reality is that you know, we share that list of advocacy organizations. You know, the neighborhoods, you know, there are citywide advocacy organizations that you know, will have that broad citywide scope, but there are also neighborhoods that have much smaller advocacy groups that are just focused on historic preservation issues within a certain boundaries. And those groups really do tend to be in the wider and wealthier areas of our city. And so, you know, to the extent that there are inequities there, you know, I think the city is, and the LPC is starting to understand that part of its role is to really fill the gaps in the areas that, for whatever reason, don't have those resources, and to recognize you know, what the important historical elements of those other neighborhoods and parts of the city are, and to protect them as well.
Do you have any suggestions of the role that community boards can play in that regard of awareness, education, and advocacy, and or things that you've seen in some community boards that you feel is a good practice for other community boards to consider?
Yeah, I mean, community boards are really a hub. You know, I'll say, you know, they can serve very often as the organizers who, you know, are the ones who are speaking to, because an effort to designate, especially when you're looking at a historic district, you've got to reach out to owners a lot, and you really got to have them not just understand what you're doing, but also get on board with it, right? There are a lot of owners who have tremendous apprehension at the idea that they would be included in a historic district, because many of them do see it as a prohibitive set of restrictions. I mean, we saw those cases go that went all the way up to the Supreme Court, right? And imagine an individual homeowner or a small landlord being faced with those restrictions and rules about what they can and can't do with their properties. And so community boards are really sort of a group of people who can organize and really speak to and advance the interests of the advocacy community that wants more designation or more attention being paid to their community, and also sort of connect that with the owners and other stakeholders to really put forth you know, a proposal for a designation. So it is a very, very long, years-long process in many cases, but it has happened. You know, recent designation of Tin Pan Alley in Community Board 5 was to some extent, you know, really community-led. And in Community Board 4 in particular, consideration right now of a historic district for Hell's Kitchen, as well as along 9th Avenue, which was historically a market, a food market on the sidewalks there. So it does happen, and community boards can be really instrumental in that process. You're on mute.
In fact, Michelle mentioned CB8 is planning a forum on preservation for the residents of their district. So that's great.
Yep.
We also have Wayne Benjamin, who weighed in again on the ADA issue, saying ADA compliance with the stoop was not required. ADA compliance was achieved through other means that did not impact the historic look or fabric of the building. So
Yeah.
thank you for that additional comment, Wayne. And then we have Michelle again from CB8 who mentions, I'm very concerned that the landmarks process will be diminished as more and more requests never reach the commission, but are handled at the staff level. And those don't come up before the community boards. Also, those plans that do go before the commissioners often have major changes to their plans, and the changed plans do not necessarily come before the community boards.
Yeah, so this is, you know, in part the 2018 change that I referred to, which allowed work that falls below a certain scope level to be able to proceed without commission approval. We have, our office has reached out to LPC on this concern. We've heard it from a couple of community boards in Manhattan. You know, just before, you know, COVID, we were in discussions with LPC to get a better understanding of what their staff level approval process for these items looks like, and to really ensure that there aren't things that are receiving staff approval that perhaps do end up having a significant impact on a historical resource. What I will say is that in general, there have been over the last, I would say at this point, couple of years, and certainly the last 3 months will be at this point an aberration, but there have been an overall, has been an overall decrease in applications that are being submitted to the LPC. I don't think the commission, the agency is exactly clear on why that is the case, but they have noted that there has been a drop in, I think, the last 2 years or so.
Okay. We have one more, things are gonna get real exciting right now, if they haven't already been exciting. So the LPC chair and commissioners are all appointed by the mayor, inviting undue political influence. You know, I didn't say this. Dave Hallowack from Community Board 4, although I'm not saying I disagree either. I'm thinking of the unjustifiable decision under the former chair to issue a permit allowing demolition of all but the street facade of the oldest house in Chelsea, which had multiple public faces. Are there any opportunities for reform, perhaps changing the makeup and appointment of commissioners?
Yeah, there can be. I am not a lawyer, so I really couldn't tell you the different ways that you might be able to achieve the requirements. I know that at least one of them is through a change in the city charter, which is one of the two things that governs the LPC, the other one being the administrative code. You know, I think some folks, we have a lot of people on this webinar who are civically engaged. We've had 2 city charter commissions in the last couple of years. I don't think that the makeup of the LPC commissioners really rose to a level of being debated or perhaps even mentioned as part of those 2 processes. But I will say that I
remember reading about the qualification, the
yes,
in order to be appointed,
exactly
it's standard of qualification, right?
Yes. So it used to be the case that maybe about 4 or 5 years ago, that the commissioners didn't really have to have any particular professional backgrounds. And so that's why I mentioned 3, I have to check my notes so I get this right. 3 of them have to be architects. 1 has to be a historian. 1 has to be a planner or a landscape architect, and 1 has to have a real estate background. So, so that is one change that was made to the makeup. But yes, David is right that the commissioners are all mayoral appointees, and you know, again, besides a change to the city charter, I don't know of any other ways that we can.
Yeah. Indiana Porta agrees with you, saying, I think that it would require a charter commission to propose a change, and then New York City voters would have to approve it.
Yep.
So in a similar light.
On a
So
ballot.
another question, is there any definitive study about the way in which property within historic districts are affected?
Is there any what?
Definitive study about ways in which property within historic districts are affected. You would need more details for the question would have to be elaborated a bit more, right?
Yeah, I think there's.
If you can elaborate a little bit more,
Yeah.
Lisette will try to answer it now, but if you can elaborate, that would be great.
Yeah, there are certainly studies that look at property values. That was a really big sticking point.
Okay, yes, he says, sorry, I intended to mention property values.
Yeah, so that was a really big sticking point, and still continues to be. There was a report maybe a couple of years ago that looked at the effect of property values when a property is designated versus when it's not. And we can find it and share it with folks. I'm not able to speak in detail of what the findings of the report was.
I also remember reading a study on the positive economic development effects of landmarking in relation to, for example, the film and movie television industry, in terms of being able to film and produce here a lot of, partly because of the historic value of preserving landmarks and the backdrop that is used for a lot of the period pieces and different movie sets that they need to do.
Yeah. And again, that gets back to the equity issue, right?
Yes. All right, so you've answered all the questions comprehensively, so we thank you for that. We thank you for taking the time to answer all the questions and for the presentation. We also thank Elka Moretti, who emailed and kept you guys in touch. I know we had a little glitch there where we had to give you another login link for this webinar. So we're glad that over 75 of you were able to make that transition and get the new link. We apologize for that hiccup. So we'd like to thank Elka Moretti from our office. And again, we'd like to thank Lisette Chaparro, who's the Director of Land Use in our office, who's also left her contact information in the last slide. And again, I'm Aldrin Rafael Bonilla, your Deputy Borough President. And we look forward to seeing you at the Conflicts of Interest training, the Advanced Land Use and Zoning training on Monday, Conflicts of Interest on Tuesday. If you can make them, that would be great. And then stay tuned for additional trainings that will be rolling out in the upcoming weeks. So again, thank you all very much. Have a wonderful evening, and we look forward to continuing to provide technical assistance, training, and support to our community board district staff and community board members, as well as residents of the community civically engaged and interested to contributing positively to their city. So thank you so much. And Lisette Chaparro, again, you have any concluding remarks you'd like to say to our community board members and the viewers?
Just a thank you to everyone for really being engaged on this and other trainings and for attending tonight.
Thank you so much. So good evening, everyone. Bye-bye.